Thank you. And I do have a question.
Yeah.
The guy in California, I'm guessing it was Roy Romer, but you can just refuse to answer that, who asked you about the school buses. Did he end up getting something done about that once you refused? Do you know what happened with that?
Yeah, he put videos in all the buses, and the children became adorable.
Could you describe your proposed constitutional amendment?
Actually, it would be very simple in terms of the right to privacy. First of all, it would extend the right to privacy beyond the government itself. It would create a standard for privacy. Part of the problem with privacy is because it's not mentioned, because it's penumbral, it suffers not just in juxtaposing against practicalities, like terrorism, but it also suffers in the fact that it does not have a footprint in the Constitution. It does not have a billet in one of the amendments. And so the justices constantly deal with it by treating it like it's some passing value. It's the same thing with parental rights. I'm a big parental rights advocate. And, but you know, they do the same thing with parental rights. They constantly say parental rights are protected in the Constitution, privacy protected in the Constitution, and you always know the next sentence is, but we're not going to, you know, defend them here. And so having it in the Constitution would make a big deal of a difference in my view.
Sir, excuse me, but I respectfully disagree with you. I know, I mean, I interviewed the Zikurishvilis from the Republic of Georgia on this we talked about this very subject. He said, Rosalind, you have this much rights. We had that much rights. I mean, today. Now, I'm referring to...
Where do you disagree with me?
With the use of, all right, the privacy is not explicitly stated in the Constitution, right, but we have the means to deal and to get around it with the First Amendment, the Fourth Amendment, the Fifth Amendment, and the Ninth Amendment as they have been used, and there are cases where you can go and see the precedent of how they have been used in Griswold versus Connecticut, in Roe versus Wade, in Lawrence versus Texas. And let's go back to 1963, Griswold versus Connecticut, which was when the government or the state of Connecticut tried to invade a married couple's bedroom and tell them they couldn't use contraceptive literature and they could not use contraceptives. And that was taken to the Supreme Court, and the law in Connecticut was struck down. They have the right, a married couple has a right to use contraceptive, and it became nationwide. That was the precursor to Wade versus Roe, and then it led to Lawrence versus Connecticut. I mean, Lawrence versus Texas, where two gay men have the right to have sex, and they wanted the shame. They wanted the transparency, and a friend of mine, Judge Janice Law, wrote a book, Sex Appealed. They wanted that case appealed all the way to the Supreme Court so that they could get that, so that gay men could have sex in their bedroom legally in the state of Texas. My question is, how would you write? I mean, to me, if you use the Constitution as it is now, it works. Leave the Supreme Court alone, they're doing fine, or people taking this to court are doing fine. How would you write that law? How would you write that amendment without screwing it up more?
Well, I'm not too sure where to start. First of all, I didn't say there weren't privacy cases. There are privacy cases. The problem is that privacy is almost always honored in a breach. That most of the cases are not the cases that you talked about. Most of the cases involve people whose privacy are found in cars, in motorhomes, the internet, where the court continually finds against them. I happen to support Lawrence v. Texas. I happen to support for the privacy of the homes, the use of contraceptives. All of that is rather obvious because I have a strong libertarian streak. I don't think the government belongs in the bedroom of anyone. But the problem is that those are the exception. That, for example, when the court looked at whether you have an expectation of privacy in a motorhome, it seemed pretty clear because the second word is home. But the court looked only at the first word, motor. and said it must be like a car. You don't have expectation of privacy in cars, by the way, because we said so. And so you can't have it in a motorhome, even though you're living in it. That's an example of the many different ways privacy loses. You're right. We might screw it up. But I don't think we could screw it up more than we are now. I think we can only improve the situation.
We have time for one more question.
Hi, thank you for your presentation. I guess the bottom line is that do we really, in effect, judging from all these Supreme Court cases and all these decisions, do we really, in effect, still have a Fourth Amendment?
Well, there's a good question. It's not like computers where you end up with 4.2 as an upgrade. This gets degraded. I think we're now to like 2.3. The answer is we do have it. It's a shambles. I mean, even Scalia admitted in one opinion that the Supreme Court has made an unholy mess out of the Fourth Amendment and constitutional criminal procedure generally. I actually have not taught constitutional criminal procedure in a few years because I hate it. Because you can't teach it. You cannot teach that subject. Because the students constantly ask you, how does this make sense? How does this case relate to this case? And all you can say is, they both involve Sandra Day O'Connor. You know, it's the only consistent thing. You know, and even Scalia admitted that there's no coherency left in the Fourth Amendment. And part of it is reasonableness. Part of it's because the court is remarkably political when it comes to the rights of criminals. And a good example of that is Miranda. You know, where we started out with Miranda, which I got to say, you know, there is a debate whether Miranda is covered in the Constitution. But the Supreme Court created Miranda, which in my view, by the way, was a magnificent, you know, rule. I mean, whether or not it could be found in the Constitution is a separate question. But Miranda was a brilliant rule. It was an elegant rule. There's few nations on earth that would tell the police that you have to educate a suspect about his rights. I think that's a magnificent thing. Not the embarrassment everyone points to. It's an amazing thing. And, but as soon as they created Miranda, people like O'Connor and others started to just create exception after exception after exception. So by the time they finally said that it was part of the Constitution, I remember the New York Times called me and said, would you do a column on this? You know, because they said finally it's protected in the Constitution. And I said, of course it is, because the EKG is flat. That's why Rehnquist is saying it's in the Constitution, because it's dead. There's more exceptions than a rule there. It is almost impossible to get a case overturned with a Miranda violation because of all the exceptions. So after cutting it to pieces, they then finally said, we like what remains. So the answer to you is not that Miranda is a Fourth Amendment issue. It's not. But much of the Fourth Amendment is like that. It's just filled with so many exceptions there lacks coherency. And what that also means is that we're not going to be able to get back the Fourth Amendment or privacy unless we roll up our sleeves and do something about it, something comprehensive, something historic. You know, in many ways, the United States defined privacy. We have a privacy right that is almost unique. Even our close cousins in England do not have the same privacy protections or free speech protections that we have. We defined it. What an extraordinary thing it would be if we regained it, if we showed the world that with all the fears and all the terrorism and all of the scaring and fear-mongering that you could do, a free people stopped and recreated privacy and a protected zone and withdrawing places. To me, that might be one of the most impressive things this republic ever did. Thank you very much.